This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why an insurance policy does not always have a duty to defend, and that breach of contract and intentional acts are not insured by most, if not all, liability insurance policies. Carl Hemphill asked the Third Circuit to find that his liability insurer, Landmark American Insurance Company, is obligated to defend him in a lawsuit by a former employee. That employee brought a panoply of claims against Hemphill in his original complaint. None is covered by Hemphill's policy with Landmark. In the case called Carl Hemphill, MJC Labor Solutions, LLC versus Landmark American Insurance Company, an April 5, 2023 decision of the Third Circuit Court of Appeals applied the Four Corners rule to resolve the dispute. Carl Hemphill and MJC Labor provide temporary employee placement and visa application processing services to workers from Mexico and Central America. Hemphill is insured by a miscellaneous professional liability policy, an MPL, with Landmark covering claims arising out of negligent acts, errors, or omissions in the rendering or failure to render permanent and/or temporary placement services. Former MJC client Jose Castillo sued Hemphill, alleging violations of federal human trafficking, wage and hour, and unfair trade practices laws, as well as claims for breach of contract and unjust enrichment. When Castillo eventually arrived in the U.S., Hemphill and his wife confiscated his passport, housed him in conditions described as filthy, overcrowded, and vermin-infested, assigned him tasks outside the scope of his employment contract, and considerably underpaid him. The parties have since settled the Castillo lawsuit, but the reimbursement of legal defense costs incurred in the underlying suit remain in dispute. Landmark declined to defend Hemphill on the grounds that the Castillo allegations arose from Hemphill's intentional actions, occurred after Castillo had been placed as an employee rather than from negligent actions in providing placement services. The Third Circuit understood that if the underlying complaint averred facts that might support recovery under the policy, coverage is triggered, and the insurer has a duty to defend. But under Pennsylvania law, the question of whether a claim against an insured is potentially covered is answered by comparing the four corners of the insurance contract to the four corners of the complaint. Courts applying Pennsylvania law must not stray from the operative complaint in determining duty to defend issues, even when later proceedings reveal the existence of a potentially covered claim. The district court found that 1. Hemphill could not expect Landmark to cover him for any claim not listed in the Landmark policy, and 2. Castillo's complaint does not allege a covered claim. Hemphill argued it was his reasonable expectation that coverage applied, but an insured's reasonable expectations, although they may occasionally prevail over the express terms of a contract, they only apply in a very limited circumstance to protect non-commercial insureds from policy terms not readily apparent and from insurer deception. Hemphill did not argue that the Landmark policy language is facially unclear or that Landmark engaged in deceptive tactics. Instead, he claimed that the mere fact that Landmark defended a different lawsuit created a reasonable expectation that it would defend the Castillo lawsuit, even though Landmark subjected its defense of the earlier lawsuit to a complete reservation of rights. The Third Circuit, dealing with the duty to defend, concluded that an insurer's duty to defend is determined solely from the language of the complaint against the insured. It is the potential rather than the certainty of a claim falling within the insurance policy that triggers the insurer's duty to defend. Castillo's unfair trade practices claim alleged that Hemphill deceived Castillo about rental housing in which he would be living. But Castillo does not allege that Hemphill or MJC ever represented to him that his housing conditions would be sanitary or not crowded, or that he would not have accepted Hemphill's employment offer had he known of the housing conditions and that they were subpar. As for Castillo's start date, his allegations amount to nothing more than a breach of contract claim. He alleges that his contracted-for start date was delayed and that he lost money and employment opportunities as a result. Landmark expressly carved out breach of contract claims in its policy with Hemphill. It had no duty to defend this one or any other claim in the Castillo lawsuit. In my opinion, the Four Corners rule allowed the insurer to refuse to defend or indemnify its insured because Castillo's suit was basically for breach of contract and did not meet any of the requirements of the policy which limited its coverages, and did not promise to defend a claim for breach of contract, or even a potential claim for breach of contract. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog on the blog site, and you'll be given notice of every blog posting, which is usually 5 to 6 a week. This video on rumble.com and on youtube.com can also be subscribed to free. And if you found the videos or the blog postings to be reasonable or useful to you, please tell your friends and colleagues so that they can also subscribe and obtain the information on the blog postings. And if you like the videos, please click on the like button at YouTube and the Rumble button on rumble.com, and also consider subscribing to my Substack publications and my Locals community. Thank you for your attention.